Here at the S.J. Quinney College of Law. I teach first-year criminal law, advanced criminal procedure, and a subject that is a seminar class that I enjoy very much, crime victims' rights, which is my topic for today. I want to talk for this hour, and I'll make sure that we have some time for questions and answers at the end, but talk about the crime victims' rights movement. I'm going to divide the talk, roughly speaking, into three areas: historical foundations. I'll talk about the history of criminal justice here in America, which I think has some important lessons for us as we think about current crime victims' rights issues. And then I'll look at what I would call the modern ascendancy of the movement. The movement's had a great deal of success over the last 40 or 50 years, and I'll describe what that success has looked like. And then I'll conclude with some future aspirations, areas where the crime victims' rights movement, I think, has additional work to do, and hopefully we'll be able to make some improvements in our criminal justice process. So let me dive right in. Let me give you a quick overview of the crime victims' rights movements. I think a lot of people who have looked at American criminal justice have concluded that this is one of the most successful movements, and I think you can fairly describe it as a civil liberties movement of recent times. John Gillis, who is the director of OVC, the Office for Victims of Crime in the Justice Department, and my friend Doug Balouf, who was a law professor at the Lewis and Clark College of Law, described it that way back in 2002. And when we look now at the roots of the movement, I'll be describing America's history of private prosecution. It's interesting, we live here in Salt Lake County, for example. We think of Sim Gill, our district attorney, and the office that he very capably runs as being the model for criminal justice, that kind of a public prosecution model. But if you go back to the earlier times in American history, when the Constitution was drafted, for example, you'll see that there was a history of private prosecution, not the public prosecution model we have now. More recently, we've seen participatory rights for crime victims become enshrined in America's criminal justice process. I'm sure some of you have seen recent examples of this, victim impact statements that victims or their families deliver. And that would be an example of the kind of participatory right that crime victims have obtained through the ascendancy of the crime victims' rights movement. And then when we look to the future, I think it's interesting to think about, given where we are in America today, are there steps that could be taken to expand crime victims' rights? I think there are, and I'll actually propose that we should be thinking about adopting a federal constitutional amendment to protect crime victims' rights. So that's an overview of where we're going, and I'm sure you can all read the subliminal message there. Or is that a little hard to read? The subliminal message, not so subliminal, of course, is I think a lot of people have a misunderstanding about America's crime victims' rights movement. It's been described as a carceral rights movement, a movement trying to lock people up or impose draconian sentences. That is not, in my view, an accurate description of the crime victims' rights movement, and I'll try to make that case throughout my presentation today. So let's go now to the history of crime victims in America, and I'll start with, conveniently, 1789, when our Constitution was drafted, up through about the 1970s. And that's a period of time where I think crime victims' rights or the criminal justice system moved from a system of private prosecution to a system of public prosecution where crime victims could be described as the forgotten men or forgotten women of the system. When you go back to the movement's roots in the past, if you look at the machinery of criminal justice that existed back in colonial America, it had been imported, of course, from England, the mother country, and it was a system where there was essentially not the kinds of large urban areas that we see scattered around America today, even here in Salt Lake City. And at that time, a more rural past, there was a system of private prosecution. So if there was a cattle rustler or something who stole some cattle, it was up to the rancher to try to identify the perpetrator, maybe could enlist the constable for the community to help make the arrest, but it was up to the rancher, or more broadly, the crime victim, to pursue a private prosecution of that individual. Many of the issues that we think about today, locking people up in federal penitentiaries for decades or whatever, were not part of the system back then. A lot of the focus of the system was on restitution. So the rancher would try to identify the cattle rustler and maybe obtain restitution for the items that were taken. So this was a system where the victim, or the public, or the citizen who was responsible would be initiating the charges. Now that, you can understand, might have some problems with it. What if there wasn't an interest by the crime victim in pursuing that particular case? Or as America became more urban, it might be possible in an era of small towns or a rural America where for crime victims to be able to identify someone who had committed a crime. But now as cities begin to develop, how is the crime victim really going to be able to identify the crime? And then would the crime victim really have an interest in obtaining restitution? Might there be offenses that go to the public interest where the public prosecutor ought to swing into action? And so at some point, these practical pressures on a system of private prosecution began to create pressure for public prosecutors, district attorneys or county attorneys in various places who would pursue criminal justice on behalf of the public. And so now I'm skipping over, 100, 150, maybe more years than that, where we transitioned from a system of private prosecution to a system of public prosecution. It is interesting that even today in America, you can still find vestiges of private prosecution. According to a recent Law Review article, which I cited in the article that I'm presenting here, essentially my article in the Pacific Law Review, Emma Kaufman, who I believe is a professor at NYU Law School, cataloged the different vestiges of private prosecution, found that, for example, in 7 states, Delaware, Massachusetts, and a few others, crime victims could initiate their own criminal justice, criminal action. And if you expand the definition of private prosecution to include situations where crime victims were assisting the public prosecutor, you see even more states that effectively allow some kind of private prosecution. But of course, in the main, if we move up to, let's say, 1970 in America, the system of criminal justice would be the system that I think many of us are familiar with: a district attorney, maybe a U.S. attorney handling federal matters. Those would be public offices, public prosecutors who would be initiating the prosecution. And the question then became, all right, what was the role of the victim in that system of public prosecution? So interestingly, if you go to 1970 or maybe 1976, the bicentennial of America, there was an important article written by Professor MacDonald who called for a bicentennial revolution in criminal justice, the return of the victim. And MacDonald very famously described the victim in 1976 as seen at best as the, quote, forgotten man or forgotten woman of the system. And at worst, the victim is twice victimized, first by the crime itself, but second by a system that pays very little attention to crime victims in the process. And that system that ignored crime victims led to the birth of the crime victims' rights movement. Picking an exact day, of course, is sometimes tricky, but certainly in the 1970s, there was a coalescence of various factors. One thing, there were five items that my friends Marlene Young and John Stein cataloged when they tried to put together a history of the movement back in 2004, 20 years ago. They said, look, there was a confluence of, for example, first the creation of an academic field of victimology. There had, of course, been the field of criminology, but within that field, a subspecialty of victimology focusing on victims began to develop. Also, there began to develop victim compensation programs around the country. So if a crime victim maybe had their home burglarized, property taken, state systems of compensation began to develop, which required then an apparatus for identifying victims, providing compensation to victims, providing some mechanism of recompense for those who had been harmed by crime. Around the 1970s, of course, there was also the rise of the women's movement that took note, for example, of the plight of rape victims in America's criminal justice system. Rape victims were essentially put on trial for their past sexual history, leading to concern about how that was diverting the focus of the criminal justice system from whether the issue of whether the defendant had committed the crime to whether the victim was of good moral character or something along those lines. And reform by the women's movement on behalf of rape victims then began to expand more broadly into other areas as well. There was also an increase in crime in the late 60s and the 1970s, which created a dissatisfaction with the criminal justice system, a sense that the failure of the system to respond was leading to increasing crime rates. And there were also a lot of crime victims who began to become very involved in the criminal justice system. And so when all those things came together, what you started to see was that by the end of the 1970s, many states began to start to develop victim assistance programs. At least 10 states had networks of these types of programs. And there began to be a common understanding of what it meant for there to be in place an effective response to criminal victimization, crisis intervention, for example, in sexual assault cases, counseling, support, information as the victim ran through the criminal justice process, compensation, and if there was a conviction in a criminal case, restitution. And again, if you want to look at some of the details, I would call to your attention my article this year published a few months ago in the Pacific Law Review that tried to catalog all these things. Well, then in 1982, there was a very significant development in the history of the crime victims' rights movement. President Reagan appointed a task force on victims of crime, a nonpartisan task force with representation from a broad group of people from different sectors, clergy, law enforcement, social work, and a variety of areas. And they produced this report released in late 1982, the President's Task Force on Victims of Crime, the report of the task force, which concluded that innocent victims of crime have been overlooked and their pleas for justice have gone unheeded and their wounds have gone unattended. The task force report called for sustained effort at the federal, state, and local levels and with allies in the private sector to try to restore some balance to the criminal justice system. That report was about 60 pages long, had a series of recommendations for different parts of government, for the private sector, and one of the key recommendations was that there should be established crime victims' rights throughout the criminal justice process and called for all 50 states to enact victims' bills of rights that would list those rights for victims. And so now if you put together a map of the United States since 1982, what you see on this slide here is that a number of states, about 36 states, depending on how you characterize things, have VRAs, or Victims' Rights Amendments, amendments in their state constitutions that enumerate rights for crime victims. Some of you who were here in Utah in 1994 might recall that Utah had on the statewide ballot in November of '94 a proposed Victims' Rights Amendment that passed with overwhelming support. That same year, Idaho passed a Victims' Rights Amendment. The initiative there was led by Larry Echohawk, one of our alums here from the S.J. Quinney College of Law. And you can see that a number of states now, roughly two-thirds, three-quarters, have passed Victims' Rights Amendments, putting into their state fundamental charter protections for victims. And even in the other states, the red states that don't have state constitutional protection for victims' rights, there are statutory protections for victims. So today in America, in all 50 states, there are victims' rights, sometimes more expansive, sometimes more narrow, as we can talk about. Now, one interesting thing that developed as the victims' rights movement was moving around the country to various states to develop these rights was, well, what rights should we be putting in there? Should we be putting in a right to the death penalty, or should we be putting in there a right to effective gun control? How broadly should the victims' rights movement conceptualize the agenda? And to sort of focus the movement then onto an area of consensus, during the later 1980s and following up even through today, many of the key institutional players in the victims' rights movement, for example, the National Center for Victims of Crime in Washington, D.C., NOVA, the National Organization for Victim Assistance, which is the largest organization of victims advocates, my friends out in Portland, Oregon, the National Crime Victims Law Institute, based at Lewis and Clark. They all adopted, informally at least, the Carrington Rule, and the basic idea was, look, there are going to be a lot of things that people say, oh, that's a victims' rights movement. If we don't regulate handguns more aggressively, we'll have more victims of gun violence. Or if we don't abolish the exclusionary rule, then criminals are going to go free. And you could see that there might be differing points of view on those kinds of things. But what the victims' rights movement decided is we can all come together, left, right, I guess in the current vernacular, red, blue, and we could all agree within the movement that there would be participatory rights for victims. And then with those participatory rights, victims could argue for longer sentences, or in some cases maybe shorter sentences, including restitution, whatever that would be, but that would be the participatory right of the victim in particular cases. And so the movement understood that conservatives might be pursuing certain issues, liberals might be pursuing certain issues, but everyone could come together and agree on participatory rights for crime victims. And this then became the guidance for the Victims' Rights Amendment. And I'm going to show you now some specific victims' rights amendments that are among those 36 that were adopted around the country. So you can see that they don't really, I think it's fair to say, track a liberal agenda or a conservative agenda. What they do track is a participatory agenda for victims, that is the right to participate in the process. And so let's take a look, for example, now I'm going to kind of start with some of the early victims' rights amendments chronologically and then take it up to current times. Florida had one of the first amendments even a couple of years earlier than our amendment here in Utah. And you can see it's very short. Victims of crime or their lawful representatives, including in homicide cases, family members, are entitled to be informed of, to be present, and to be heard when relevant at crucial stages in the process. And so those are some of the core rights. Notice, it used to be the case that victims might have the case moving along and they wouldn't even know when the hearings were or whether there was going to be a plea bargain or whether there was going to be a trial. Perhaps they would learn about the trial if they were subpoenaed as a witness, but they didn't have an absolute right to that. Florida, among other states, changed that in 1988 and also gave them the right to be heard. The most prominent example of that is at sentencing. And so if the issues were what kind of a sentence should be imposed, of course, the prosecutor, the defense attorney would speak to that. But in Florida after 1988, the victims, or in homicide cases, victims' family members could speak to that. So that was back in 1988. You can see that's a pretty short list of rights, basically 3 rights. But now if we move forward to 2008, one of our larger states here, the largest, I guess, by population, California, in 2008 passed its Victims' Rights Amendment. And you can see there a list of 16 rights. I won't read through all of them, but just to highlight a couple, let's see, to item 6, just to pull one out, to a right to reasonable notice and to reasonably confer with the prosecutor upon request regarding the nature of the case. And so we go from the forgotten man or the forgotten woman to now victims having the right to talk to the prosecutor. And you'll notice here that we're taking a system of public prosecution. California famously has district attorneys initiating the charges, but the victims have a right to have input into that system of public prosecution under the California Victims' Rights Amendment. One of the rights that the victims get is the right to notice. That would be item 6 as well, the right to reasonable notice. How does reasonable notice, how is that provided in California? And here's an interesting slide. This is the California amendment was called a Marcy's Law. And part of Marcy's Law was that there would be a card that lists here, and you can see, I guess it's actually 17 rights on the card, including the right to receive this card, which was then disseminated to victims. So if the police are responding to a burglary, let's say, they might collect whatever evidence was available, but then they would leave this card that would provide to crime victims information about their rights. Interestingly, this card was prepared by the then California Attorney General Kamala Harris, available in multiple languages because not all victims would be fluent in English. And so this is an example. Now you see the victims' rights movement obtaining more and more rights to notice. Here's, for example, of Florida, which in 2018, so now moving up to 2018, remember the earlier slide where there were just 2 or 3 rights in Florida. Now we've gone to a Marcy's Law in Florida that has a long list of rights. And so, what are some of the rights that are very common in the, I guess, 36 states that have constitutional protection, or even all 50 states if you were to look at statutes? I'll focus in on the constitutional amendments here, but I think they're typical of what you would find even in the other states. You'll notice one of the very common provisions is the right to notice of court hearings. Really, how are you going to be a victim and be involved in the process at all if you don't know when the hearings are occurring? Also, they have the right to attend those court hearings. You might wonder, aren't trials public? Why would they be excluded? One of the abuses in the process that the victims' rights movement highlighted was defense attorneys began, and I think this is a fair way to present it, they began serving subpoenas on victims even when there wasn't any genuine need for the victim to provide testimony. Famously or infamously in Maryland, a homicide victim's mother who was not present at the scene of the crime when her daughter was tortured and murdered, was subpoenaed to identify her daughter's underwear or something like that by the defense. And then the argument is, well, now that you're under subpoena, you're a witness and you can't even attend the trial. So that was, as a response to abusive subpoenas, the right to be present was added. The right to be heard at important hearings. Typically, the 3 hearings that are covered are bail hearings. So consider a domestic violence case where the defendant is arrested. The victim might want to press for certain arrangements or restraints on the defendant. The right to be heard at a plea bargain. So if the prosecutor and the defense attorney and the defendant have reached an agreement, what if that's an inappropriate disposition? Judges typically review plea agreements, and now victims have the right to be heard on that. And also the right to be heard at sentencing, as we'll talk more about later. So those are all very common provisions. Here are some other provisions that are common. For example, the right to be treated with fairness, dignity, and respect is found in 24 of the, when I did this survey, 34 amendments at the time. Right to restitution, right to confer with prosecutors, right to a speedy trial, just as the defendant has an entitlement to move things along, so too in many states does the victim. And also a right to reasonable protection. There are some unusual provisions. Let's see, some states give the victim the right to refuse discovery from the defendant. The defendant is, of course, entitled to confront the victim at trial. But should the defendant be able to access all the confidential records of a victim, counseling records involving counseling that might have been necessitated by the crime? In 5 states, the answer to that was the victim has a right to decline that. And there are some others here as well. So that's a quick survey of the kinds of provisions that are out there. Let's drill in a little bit on this crime victim's right to be heard, which is one of the most important rights. And here we can go back again to 1982 when the President's Task Force on Victims of Crime surveyed the landscape out there and found that victims were not receiving appropriate consideration in the process. And so the task force said the victims, no less than defendants, are entitled to have their views considered. Judge can't make, for example, a bail decision or a decision on a plea bargain or sentencing decision without hearing from the victim. The point being here that the victims aren't entitled to veto what's going on in the criminal justice system, but they are entitled to a voice in that process, and then the judge, having heard all the information from victims as well as others, can make an appropriate decision. So it's interesting to look at the trajectory of this. Victim impact statements, there were 8 states in 1981, which is 1 year before the task force report. Then in 82, the task force said all 50 states should make this a right. By 1986, just, 4 years after the task force report, 39 states had done that. And if we move up to 1999 and through today, all 50 states give victims the right to be heard, at least at the sentencing hearing, which is why victim impact statements are so prominent. It's also interesting, too, my focus today is on United States law, but some people have said, oh, the victims' rights movement, that's kind of just a law and order thing here in the United States. That argument really fails to consider that the developments I'm describing here in the United States are paralleled by developments in Europe, Asia, Latin America, transnational organizations like the International Criminal Court, the ICC, where victims were also given the right to participate at various points in the process and give victim impact statements or something analogous in many places. Even the Supreme Court got involved in looking at some of these issues. There was a 1987 case, Booth versus Maryland, which held that victim impact statements were not admissible in capital cases because of the seriousness of the charge, and because, in the view of the majority in that case, victim impact statements took the focus away from the defendant and the defendant's sentence. But a few years later, 4 years later, in Payne versus Tennessee, by a 6-3 vote, the U.S. Supreme Court said that hearing from family members in homicide cases does provide relevant information for sentencers, and reversed the earlier decision. Payne versus Tennessee had a concurring opinion by Justice Scalia, my old boss from when I graduated from law school. He said that Booth's stunning ipse dixit, that a crime's unanticipated consequences are irrelevant to the sentence, conflicts with a public sense of justice keen enough to have found a voice in a nationwide victims' rights movement. So this is an example of our U.S. Supreme Court recognizing the movement even as long ago as 1991. And if we think more broadly about victim impact statements and their general legal acceptance at this point, one of the things that's interesting to look at is those of you who are lawyers or law students, I know, have been exposed to the MPC or the Model Penal Code, the sort of preeminent model for how criminal justice laws ought to be written in America. It's been described as a remarkable effort to professionalize criminal law. Well, today, at least as of the last 10 years or so, the MPC has put into its provisions something for victim impact statements. So this is not something that is outside the mainstream. It is something, in fact, that is completely within the mainstream of the Model Penal Code. And it's interesting when you look at the report that accompanied the Model Penal Code's enshrinement of victims' rights enactments. The reporters for the MPC, 2 distinguished law professors, said that from both a policy and practitioner perspective, the ascendancy of the crime victim is one of the most important developments in American criminal justice in the late 20th century. And then it goes on to say that there are many areas where victims' participatory rights would seem to be at least arguable, and concluded in particular that there should be a victim's right to deliver a victim impact statement and a victim right to seek restitution. So legally, victim impact statements have been accepted, but I also think it's interesting to look at the cultural acceptance of victim impact statements. And here I'll refer to Chanel Miller. Some of you might recall that she was raped on the campus of Stanford University by a swimmer. The case went to trial. There was a conviction, and then the judge really didn't pay much attention to her plight and to her victim impact statement. So her victim impact statement then was picked up on the web and went viral. And I think it's interesting to see what was the reaction to that victim impact statement being broadly disseminated. One person who read it was then Vice President Biden, who wrote, "Dear Doe." At that time, Chanel Miller was going by Jane Doe. "I do not know your name, but your words are forever seared on my soul." Went on to commend her for making her victim impact statement public and explaining the kind of harm that was involved in a crime such as the one that was inflicted on her. Biden also concluded that the distribution of the statement was positive. If everyone who shared your letter on social media draws on the passion, the outrage, and the commitment, then hopefully there will be reform. Hopefully people won't turn a blind eye to these kinds of crimes. So I'm citing this not to necessarily agree with President Biden on the details or the particulars of this particular case, but just to show that victim impact statements are widely accepted and discussed in the current public atmosphere out there, or cultural acceptance. There we go. That's the word I was looking for. Here's another example of the cultural acceptance of victim impact statements. Some of you might recall that in January 2018, a former USA Gymnastics team doctor, Larry Nassar, was sentenced, and the judge in that case allowed 168 direct and indirect victims of his abuse to deliver victim impact statements. They were televised. And again, I think that shows the cultural acceptance of victim impact statements. I didn't see very many people arguing that the victims in that case should be prevented from delivering a statement. And one last example is kind of interesting. This is some of you will recall the murder of George Floyd in Minneapolis by police officer Derek Chauvin. At his sentencing, the family members representing George Floyd were able to deliver a victim impact statement. And again, I didn't hear anyone arguing that that was inappropriate. In fact, there's a small anecdote. Even prisoners in various prisons were watching the victim impact statements as well, showing, again, I think, the cultural acceptance of victim impact statements in modern America at this time. Well, let's see. What else should we talk about? How about in the federal system? The federal system has adopted victims' rights through the CVRA, the Crime Victims' Rights Act, which was enacted in 2004. In 2015, there were a couple of additional rights that were enacted, and I won't go through all 10 of the rights that are there, but you can see they parallel the kinds of state rights that, for example, Florida and California and other states have added into their state constitutions: the right to be heard, the right to confer with prosecutors, things like that. And I think what we start to see then with litigation under the CVRA is a way of reimagining America's criminal justice system. Very famously, Judge Kaczynski, in a widely quoted opinion from the Ninth Circuit in 2006, said that the criminal justice system has long functioned on the assumption that crime victims should behave like good Victorian children, seen but not heard. The Crime Victims' Rights Act sought to change this by making victims independent participants in the criminal justice process. And so if we're reimagining what American criminal justice looks like today in 2025, you'll see this slide that depicts the well of the courtroom. And you'll notice that unlike what you may have seen on TV occasionally, rather than there being just two tables, one for the prosecution and one for the defense, modern American criminal justice, at least if we're going to reimagine it, has three tables: one for the prosecutor, one for the defense, and one for the victim to be able to be heard. We see this in other ways as well. One example is a case that I was proud to have argued before the U.S. Supreme Court. The case caption was United States versus Paroline, but functionally the case was U.S. v. Paroline versus Amy. Amy was my client, who was the victim of child sex abuse imagery, and the issue that came up was what kind of restitution should she be receiving for that victimization. The defense said she should be getting zero restitution. I argued for substantial restitution, and the government argued for something in between. And so the important point here, the interesting outcome, I lost the case 5-4, depending on how you count the votes. But shortly after that, the Supreme Court had said the restitution statutes need to be reformed. And so two senators, our home state senator, Republican from Utah, Orrin Hatch, and New York Senator Chuck Schumer, a Democrat from New York, obviously, came together to put together a bipartisan bill that effectively overruled the Paroline decision and provided effective restitution for victims. We also see victims' families challenging vested interests. This is a picture of me with some of my clients in front of the U.S. Court of Appeals for the Fifth Circuit in New Orleans. I've been very honored for the last 4 years to represent a number of family members who lost loved ones in the crashes of two Boeing 737 MAX aircraft. It's now been proven that Boeing lied, with the result that 346 people died. Boeing concealed the information about the safety of the 737 MAX, or the lack of safety, from federal regulators. And that then has led to a long litigation, which I'm happy to field questions about. But most recently, just in, in May, the Justice Department decided to drop the charges against Boeing through a non-prosecution agreement. And I traveled to Fort Worth, the Northern District of Texas, Fort Worth Division of the Northern District of Texas, representing family members, that some of whom you see here, to argue that the case should move forward. Reluctantly, Judge O'Connor, the district court judge, concluded he had no choice but to dismiss the charges, but almost seemed to call for the Fifth Circuit to overturn that decision. And so just 2 weeks ago, I filed petitions for review in the Fifth Circuit on behalf of my clients, and briefing will be completed in early January, and I may have a chance to go to the Fifth Circuit. Again, this photograph was taken back in July of 2023 when I argued in front of the Fifth Circuit that victims' remedies were available in that case. So those are some examples of what I think is the ascendancy of the modern crime victims' rights movement. But there are some things in the future that maybe I'll just highlight here briefly, and then happy to take questions. Should there be an agenda now for the crime victims' rights movement as it moves forward? I think the movement has been successful in enshrining those bills of rights that I've described. But I do think there are important future steps that the movement should consider. Probably the most important thing is expanding victims' access to legal counsel. The cases that I've described, that I've worked on, I handle on a pro bono basis for victims. But there are, obviously, I can only handle a few cases. There are thousands, if not tens of thousands of cases around the country, both in the federal and state systems. And it's been difficult, I think, for many victims of crime to obtain legal counsel. I'm very proud that here in Utah, we have the Utah Crime Victims Legal Clinic run by one of my students who took my victims' rights seminar, Heidi Nostell, and she and a very capable group of, I think they have 4 lawyers now, try to cover the entire state of Utah and provide legal counsel for crime victims. But you can see that that would be a Herculean task, given the thousands of criminal cases that happen. So I think we need to look at funding mechanisms and other ways of obtaining legal counsel for crime victims. Another thing that I do think is important is enforcing victims' rights enactments, including some of the open-ended clauses. I haven't had time to talk a lot about, for example, the right to fairness, respect, and dignity, which is found in various state constitutions. We have a provision like that here in Utah, for example. But there's really been very little litigation about what that means exactly. And I think we should have more litigation about that. There should be more enforcement of those rights to make sure that crime victims are treated fairly. Also, I think it's important to consider how can we increase clearance rates here in the United States. I've talked about victims' rights in cases that are moving forward through the process. But some of you might say, well, wait a minute, how many cases actually move through the process? The answer is about 80% of America's serious crimes do not move through the criminal justice process because they are not cleared or solved by law enforcement. So that's, again, I think something that everyone could agree on, that having only 21% of America's serious crimes solved is a major problem that needs to be addressed. Overall, for a serious crime committed in America, felony crime, the conviction rate is something like 4%. So those are issues that I think need to be considered. I think we also need to consider issues of victims' involvement in the criminal justice charging process to address lack of prosecution in cases involving marginalized communities. One of the key examples of this is sexual assault. If you look at rates at which sexual assault cases are prosecuted in Salt Lake or indeed anywhere in the country, you find even lower rates than I was suggesting just a moment ago with some of those statistics. And I think one of the ways that could be improved is by more engagement with victims at the charging process. We also should look at possible alternatives to adversarial criminal justice in some situations. So, for example, I've mentioned restitution at various points. There's a lot of interest in restorative justice proceedings, which are heavily invested in restitution kinds of issues as an alternative to incarceration. Obviously, let me be clear, there are many cases that I don't think fall within a restorative justice model. Nobody is saying for a murder or something like that, that would be appropriate. But there are a wide range of cases where maybe those kinds of alternatives might be appropriate. I also think we need to think about expanding the modern state amendments, these Marsy's Law. California has one, Florida has one. I was trying to remember what the exact count is now. Something like 12 or 13 states around the country have these newer, modern versions of Victims' Rights Amendment. I think we should be trying to head in the direction of having that in all 50 states. And then I'll end here. I think maybe the last thing the Victims' Rights Movement should be thinking about is enacting a federal constitutional amendment protecting crime victims' rights. That was first proposed by the President's Task Force back in 1982. And there have been various versions of the amendment. I testified back in Washington in 2015 in support of this version of a constitutional amendment. And so I think that would be a useful step that would elevate to our nation's charter the rights of crime victims and signal that there is commitment to protecting crime victims throughout the process. So in conclusion, I'll just give you the last few words from my law review article that I published a couple of months ago. I argue that we now have a strong basis for expanding crime victims' rights, both on a practical and theoretical level, and it's important that we honor the rights of crime victims in our criminal justice system. So I'll stop here. We have a few minutes for questions, and happy to entertain any questions or thoughts that anyone has.
Great. I can...
Actually, let me, we have one person here. Yeah. Oh, thank you. Yeah, we have a microphone so that others can hear.
Okay, thank you. Can you attribute some of the shift towards more victim rights with, more equality with races and women's rights? In other words, like when people were enslaved and women couldn't vote, and since minorities have been speaking up, then the majority has to listen to the minority. Does that play a role?
The question was, do you think the civil rights movement or the women's rights movement plays a role in crime victims' rights? And the quick answer is yes, I very much do think that's the case. One of the things, for example, the crime victims' rights movement looked at in the late 60s and early 70s was criminal justice systems. And for example, the Deep South did not take seriously crimes committed against African Americans. And that was part of the response of the crime victims' rights movement to make sure that those crimes were taken seriously, treated seriously. I've mentioned the women's rights movement, which did things like enact rape shield rules throughout the country. I remember Jan Graham, I think, signed a Utah's rape shield law into effect or rape shield rule in any event in 1994, about the time that our Victims' Rights Amendment was being passed. So I think that you can find strands of that, of those movements in the Victims' Rights Movement. And I think your broader point is right as well. One of the things that the Victims' Rights Movement does is elevate voices of private citizens who might otherwise be marginalized in what are, after all, government bureaucracies. I don't mean to disparage our Salt Lake County District Attorney's Office, but that is a government bureaucracy, just as, New York or LA, I'm not picking on our office here, but having victims be able to give their own independent view on these issues, I think, is a useful check on public power. Yeah, there's some other. We have another question here in the auditorium.
Do victim rights, are they advocating for sort of like an eye for an eye, that they can inflict punishment on the crime, on the person who committed the crime, that commensurate to the punishment that was, or the violence that was inflicted upon the victim? And secondly, where does the restitution come from, financial restitution?
Yeah, let me take the second question. Where does the restitution come from? It would be coming from the criminal defendant and ordered to pay as part of the sentence in the case. So, for example, in the Paroline case that I argued to the U.S. Supreme Court, the restitution would have come from defendant Paroline, who was convicted of a crime involving Amy's images. On the eye for an eye point, the key point about the victims' rights movement is that it tries to get voices for victims heard. Some victims might argue an eye for an eye or whatever they want to argue. But actually, when you look at the victims as a group, crime victims as a group, you discover that they have diverse views like any other large group. Some maybe want restitution rather than a long prison sentence, or others may want to forgive rather than punish. But some may want to punish as well. And so the victims' rights movement doesn't have a particular agenda for severe punishment. It has an agenda to make sure the victim's voice is heard.
Okay, so from our Zoom viewers, we have a couple of questions. The first is, do you see the defund the police movement replacing cops with social workers and cashless bail as further weakening victims' rights?
Yeah, so the question was, what about defunding the police or transitioning from law enforcement to social work? I guess is that the question. I view those as separate issues from the victims' rights movement. It may be a good thing to transition away. It may be a bad thing. I know there are competing points of view on some of those issues. But the victims' rights movement tends to focus on victims' voices in criminal cases that are moving forward through the process. So I'll just say my own personal view is I'm in favor of anything that will increase the number of cases that are solved, the number of cases that can then be pursued appropriately within the criminal justice system. I think some of you might know that I was a federal district court judge from 2002 to 2007, and I wrote some opinions decrying mandatory minimum sentences. So this isn't about trying to figure out how we can lock people up for the longest possible time. It is about trying to figure out how can we appropriately respond to high levels of criminal victimization in America, and then make sure victims' interests are considered through the process.
And the next question is, how can we assist victim rights committees in determining when a victim's right to being treated with fairness, dignity, and respect was violated? Committee members feel this is subjective and are hesitant to find a violation of this right.
Yeah, so that's a good question as well. What happens, for example, here in Utah, there are victims' rights committees who investigate violations of crime victims' rights, but there isn't a lot of developed case law on what it means to treat a victim with fairness, dignity, and respect. And so that puts people like those committees or judges, I think, in a bit of a bind because there isn't a well-developed body of law on those issues. I think the solution for that is to begin developing a body of law on those issues. For example, I mentioned that 2 weeks ago I filed a brief in the Fifth Circuit, and one of the arguments I'm making there is that the victims' families in that case were treated unfairly, and hopefully the Fifth Circuit will agree with my argument, or at the very least write an opinion explaining what those rights to fairness look like and what they encompass.
Perfect. And you just answered this next question a little bit, but this next question is, with expansion of victims' participatory roles in criminal proceedings, what future developments do you foresee, and how might the justice system adapt to ensure that victims' voices are strengthened without compromising due process?
Yeah, so I think, I'll go back just briefly to to my slide here, there are some things that I think can be done to strengthen victims' rights. One is, and it's not a coincidence, this is at the top of the list, is I think we need to make sure that crime victims, particularly those with complex or legally difficult cases, have access to legal counsel. Some of you might be familiar with the 1960s Supreme Court decision, Gideon versus Wainwright, which guaranteed even indigent defendants access to counsel because of the complexity of American criminal justice processes. I think we need a Gideon moment for the victims' rights movement here in the United States that would start to make legal counsel more broadly available for victims.
Great, and it looks like we have one more question. Where does restitution come from if the defendant does not have the means to pay it?
Right, so if the defendant is unable to pay restitution, then the defendant doesn't pay restitution. But when I was a judge, it was interesting, even defendants who seemed to have very limited means could pay modest restitution. For example, in the federal prison system, some defendants will pay $25 a quarter or $100 a year in restitution out of their earnings at the prison. And so judges look at the ability of a defendant to pay, and obviously, if there is a large restitution award, they have incremental payments that are tailored to the defendant's income.
Okay, and then we actually just had one more question come in. Given that the victims' rights movement is centered on amplifying victim voices rather than increasing punitive outcomes, what guardrails or policy structures are necessary to preserve the movement from being unintentionally perceived?
Yeah, it's an interesting question. I think the question was, how can we keep the movement from being inappropriately perceived as nothing other than a guise for lock 'em up or something along those lines. I think the solution to that is, and I'm smiling just a little bit because I'm a law professor here giving a speech, I think we need more education at law schools, in bar associations, and in the broader public about how victims' rights actually operate. And I think the more people learn about victims' rights, hopefully you all have learned some things today that'll be useful. I think the more people learn about the movement, the more they begin to understand that it is a broad-based movement designed to elevate victims' voices and not to take sides in some kind of a political dispute. I think maybe we should stop here. I see some questions in the auditorium, and I'll be happy to stay and chat with people here, but thank you very much, and please feel free to take a look at my article in the Pacific Law Review if you want to learn more about this subject. So thank you very much.